Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
No delaying for what you saying, yo. Said it with my 9 million with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, every while in the studio. You don't wanna vibe, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the toolie, yo. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, nigga, wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fucking seats what you got for me. Put more than hands with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fucking seats what you got for me. Put more than hands with my eyes to see. Stop $1 in a place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fucking seats what you got for me. Put more than hands with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fucking seats what you got for me. Put more than hands with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fucking seats what you got for me. Put more than hands with my eyes to see. Stop $1 in a place to be. If you really my heart to me. Fucking seats what you got for me. Put more than hands with my eyes to see. Stop $1 in a place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Yo, 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 yo. What's up, my people? Can y'all hear me out there? Do I sound loud and clear? What's up, Jacqueline? Jackie in the building. Hammer time. What's up? What's up? What's up? And what's up to everybody else that's in the bushes, hanging out in the bushes? Honey bunny. What's up, my honey? Hi, baby. I see you finally got the notification. Yo, YouTube be tripping. It be doing the same shit to me, yo. Even when I have my my subscriptions, the way I have it, it's usually on like the most relevant or most recent or something like that. So when I put it up and I look at my subscription, I go, okay, but what happened to everybody else I was always watching? And I have to go all the way down and click their channel and go watch their commentary or whatever it is that I missed. And then all of a sudden they'll pop up again. It's weird. YouTube's got this weird algorithm thing. I don't get it, but whatever. I'm glad you're back, babe. So, Mr. Don, the con, Russell, the muscle, the hustle man. Right. Yeah, he's back. Well, actually, the government has responded to his silly tactics. You know, I mean, he has rights, you know what I mean? I'm just making fun, just because I'm a funny girl like that. But on a serious note, he did put in a motion to vacate his conviction as well as his sentence. And he is acting pro se, or pro se, however you want to say it, which means he is defending himself. He is a sovereign citizen, a natural man, walking this earth, and he don't need nobody. His laws are his laws. Yo, I tell you, these natural people are funny. They be conspiracy theorists and everything. Yeah, he delayed. He definitely delayed. Way, way, way. In his way, way past when he was tap dancing in the subway, and R. Kelly was on the other side of the bench playing his piano. The other one's tap dancing on the other side of the bench. Yeah, no. So he decided to put it in this motion, and it went into Judge Donnelly, and now the government has responded to his motion, and they oppose of it, of course. We all know he took a plea deal. Um, he was supposed to do like 25 to 35 months, I believe it is. I'm not correct on that. I'm not exact on that number, but it should be around that. Just estimating. Um, and instead, with his plea deal, he got 20 months. And he's crying like a big baby about 20 months. Now, there's also another problem that Don is involved in, and it has to do with the lawsuit for the pain and suffering of some of the people who were at the screening of the Surviving R. Kelly documentary in New York City in the Newhouse studio or theater, Newhouse Theater. And this went down back in 2019 or 18. I don't remember which time. And he was convicted of making the threat to the theater. And this charge was in the Southern District of New York. And he was convicted there of the threatening of the theater. Okay. So he got 12 months for that. Now, with this case, is from the Eastern District of New York, to where he was stalking and harassing the Rogers. Okay. And we know the Rogers, Faith Rogers and Kelly Rogers, Charles Rogers, the Rogers family. My family. I love you guys, by the way. God bless you guys always. And so he was convicted for stalking and harassing them. Interstate commerce. Okay. Which means from state to state. So it's a federal charge. That's why it was in a federal court. And then he came back and besides this motion to vacate, he also made a complaint last time about harassment in the prison, that he wasn't comfortable, that he felt like his life was being threatened because these guys wanted his paperwork and he's being scary in there. He went and wound up putting himself in PC because he didn't know what's going on. He feels like people are going to beat him up, you know. And so, yeah. And then he talked about the bloggers and how a few bloggers out here are stalking him and harassing him and defaming him online. He called them all out by name. He said Dana, Sharon, and Hollywood. That was a funny motion. Hey, Purple Purple, what's up, my lady? So here he is being a bozo. Yeah, no. And he also has a problem because he's part of the lawsuit, like I was saying, with R. Kelly for $10.5 million that's going to go to some of these people who were part of this new house theater. They were part of the screening of Surviving R. Kelly. They were there. And it has to do with some of the accusers and some of his people. And R. Kelly is striking back. Hey, Rockin', what's up, baby? R. Kelly is striking back, guys. Hey, grown little boy, what's up, Poppy? So R. Kelly's striking back because he feels like, listen, I had nothing to do with that. I did not tell this bozo to go and do that. Him and his mother had some kooky idea to intimidate the Rogers. That was his plan, his idea. I didn't tell him to do that. And as far as him doing this bullshit that he did to the theater and the Surviving R. Kelly screening and those people have nothing to do with me. So R. Kelly is challenging the $10.5 million intimidation lawsuit settlement and says that he is not responsible. So this happened in August, all right, where 6 women were awarded $10.5 million following the lawsuit, okay? And it was from the December of 2018 screening of Surviving R. Kelly that took place in New York City. And at that time, when that happened, the event was shut down temporarily, okay, as soon as they got the threat and the intimidation tactic that Don the Con decided to do, right? However, R. Kelly is like, hell no. He's pushing back. He's not paying anybody else no more money except for the IRS. And that's who he got to pay next. And anybody else he might owe on the slide that we don't know about. It's personal shit. Right? So he's pushing back on this settlement, okay? And he's saying that his co-plaintiff, as we know him to be Don Russell, he is the sole person to blame for this. And that he should be held financially responsible, not R. Kelly. And R. Kelly is also denying that Don was ever his manager. And he's also saying that he didn't know, he had no knowledge at all that Don Russell was going to do these things. He's saying that Don did that shit for his own reasons. That he's saying that he was even unaware of the lawsuit. And that if he was aware of the lawsuit, he would have defended himself. And R. Kelly's like, it's hard for me to keep up with all these lawsuits. And it's even harder because he's changed his legal teams a couple of times. And even if he had been aware of the lawsuits, R. Kelly's saying that he would have concluded that he wouldn't have been able to understand the legal jargon because he can't read or understand words beyond that of a grade schooler. And we all know that he is a functioning illiterate according to his mitigation report. He's not dyslexic. Let's get that straight. R. Kelly is not dyslexic. Okay? He's not. He is a functioning illiterate. That just means he doesn't know his hooked on phonics, okay? That's all that means. He can read some words if he puts them together. He has up to a 3rd grade education. Okay? Let's not be fooled by the bullshit. All right? All right. Now, as we know, there's a lawsuit because of the fact that the victims that are alleging in the lawsuit that they were triggered by the trauma. Okay? And some of them suffering from PTSD and panic attacks. And each of them is set to receive $1.1 million and $2.25 million each, between $1.1 million and $2.25 million each. Now we know that Judge Donnelly ordered that R. Kelly paid restitution and that it was garnished from his royalties, and that's how he was able to pay the restitution, and that was of $506,950,000. Okay, and before that, we know that $28,000 was confiscated from his commissary, which was taken at first to apply towards his debt. You know, just to kind of be like, listen, well, I'm going to put this down just to assure you that you will get your money. So that's why they took that money the way they did. Okay. So that's what's going on with that, right? It's crazy, right, guys? Hey, the truth. What's up, mommy? He's a master manipulator. He wasn't his manager. So he's finally standing up about something. Yeah. R. Kelly's like, yeah, he's not going to take me down with him. No way. He did this shit all on his own. Nobody told him to do it. He did it because he wanted to help. And R. Kelly saying he had no knowledge of none of that shit. So, yeah. So now the government, like I said, has responded. Okay. Let me share my screen with you guys. Okay. All right, you guys can see that. I'm gonna go to solo layout, I guess. All right. Where is... Okay. All right. Okay. All righty. So here we have it. I had to do it this way because for some strange reason, I was not able to upload the download to my PDF file. It kept saying something about an error. So I had to screenshot every damn page. Okay. And here we go. So this motion came out on December 21st. Unfortunately, I would have brought this to you guys sooner, but I had to pay my pacer first. So as soon as I paid my pacer, I was able to get it down. So here we go. So this was going to Judge Donnelly, and this is the document from the government. And it's United States versus Donnell Russell, docket number 20427. And it starts out like this. Dear Judge Donnelly, the government respectfully submits this letter in opposition to the defendant's pro se motions to vacate his conviction and sentence under the 28 United States Code, Section 2255, and for bail pending the court's resolution of that motion. And then it says, see electronic filing number 47 through 48 on July 26th of 2022. The defendant pleaded guilty pursuant to a plea agreement to the sole count of the indictment, which charged him with interstate stalking from November 2018 to February 2020. So he was stalking for 2 years, the Rogers. Okay? Faith Rogers and her family. And this is in violation of 18 USC section 2261A 2B. On November 17th of 2022, the court sentenced the defendant to 20 months imprisonment, which was 4 months below the bottom of the applicable guidelines range of 24 to 30 months imprisonment. So he was supposed to get originally anywhere between 24 to 30 months. And because he pleaded guilty, they gave him 20 months. And he's crying about this, okay? Because he's a tap dancing fool. You see how it works? A bozo. Right. So the defendant now moves pro se pursuant to section 2255 to vacate his conviction and sentence based on ineffective assistance of counsel. Now, remember what we were saying the last time, that his counsel, he said his counsel was coercing him, right? Now, and it was because he wanted to rush him because he had to go on a vacation or some shit or whatever. So now, specifically, the defendant argues that his counsel's performance was constitutionally deficient because counsel allegedly failed to advise the defendant of 4 possible defenses. And that would be 1, actual innocence. Bless you, sweetheart. 2, a 6th Amendment venue challenge. 3, a void for vagueness challenge. And 4, First Amendment challenges. And as you know, the electronic filing, the docket number was 48 at lines 17 to 18, or pages 17 and 18, right? So the defendant's argument, now the government, that the defendant's arguments are meritless. What does that mean, guys? What does meritless mean, guys? What did I say when I was reading his motion? This shit is trash. Moot. Meritless. And what did the government say? The defendant's arguments are meritless. I can't say anymore. Mama Rogers, what's up, baby? Let me give you a wrench over there. I don't know why you don't have the wrench. Okay. Hi, baby. How are you? Okay, enjoy your Bible study. God bless you. Prayers are up for you always, mama. Hey, Sonia, what's up, baby? Long time no see, mama. Honey said no shit. So, the government continues to say, as explained further below, none of the above listed challenges would have been likely to succeed in this case. Womp, 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 womp. You hear that, Don? Or PC Tech? Because I'm pretty sure you're going to come in my comments. Whoever you are that's on Don's side, family member, because it was the mother's page, June Barrett's page. So if mom, you have an issue with me talking about his paperwork, I'm sorry, but it's public information. And I'm just here to read it. And yes, I'm here to laugh at your bozo son because he's an idiot. Okay? And you should have been telling him he's an idiot too if you was a good mother. All right? Okay. So, accordingly, even assuming arguendo that counsel did not discuss them with the defendant, that would not have rendered counsel's assistance constitutionally ineffective. And in any event, the defendant did not suffer any prejudice. Accordingly, the court should deny the defendant's motion to vacate. For the same reasons, the court should deny the defendant's motion for release pending resolution of the motion to vacate. Okay? Oh, no. I gotta go backwards. So now they're going to talk about the relevance of the background. Okay? A, the offense conduct. As set forth in the pre-sentence investigation report, the PSR, and described further below. Between November 2018 and February of 2020, Russell, a self-described manager, advisor, and friend of Robert Sylvester Kelly, also known as R. Kelly, repeatedly harassed and intimidated Jane Doe and her mother after Jane Doe filed a civil lawsuit against Kelly. Specifically, Russell threatened to publicly reveal sexually explicit photographs of Jane Doe and to publicly reveal her sexual history if she did not withdraw her lawsuit against Kelly and cease her participation and association with the organizers of a negative campaign against Kelly. By way of background, and as the court knows from evidence introduced at trial in the United States versus Kelly, including testimony from Jane Doe, Jane Doe met Kelly at one of his concerts in approximately March of 2017 when she was 19 years old. In the ensuing months, Kelly used force and threats of force to obtain sexual services from Jane Doe, including, for example, displaying a firearm while he demanded Jane Doe give him oral sex. Jane Doe ultimately learned that she had contracted an infectious venereal disease during the course of her relationship with Kelly. On May 21st of 2018, Jane Doe, through counsel, filed a lawsuit against Kelly in New York County Supreme Court. The lawsuit alleged multiple causes of action against Kelly related to Kelly's sexual interactions with Jane Doe, including sexual battery, civil battery, negligence, and gross negligence, intentional infliction of emotional distress, fraud, concealment, and false imprisonment. The lawsuit sought general and special damages, compensatory damages, punitive, and exemplary damages in amounts to be determined at trial, as well as costs and reasonable attorney's fees from Kelly. The lawsuit included the address for Jane Doe's attorney in Brooklyn, New York. In 2018, in November of 2018, Russell caused a letter with attachments purportedly signed by Kelly to be mailed to Jane Doe's attorney in Brooklyn, New York. The letter stated, among other things, the following: please advise Jane Doe, your client, to abandon this heartless effort to try to destroy my musical legacy for selfish, personal enrichment. If she persists in court action, she will be subjected to public opinion during the discovery process. For example, my law team is prepared to request the production of the medical test results proving we'll get to the rest. And here on the bottom of the footnotes, it says, also enclosed in the envelope were a one-page notice of delivery signed by June Barrett, the defendant's mother, and a copy of the cover page for the lawsuit, a summons in the lawsuit addressed to Kelly, and the first page of the verified complaint and demand for jury trial for the lawsuit, with the following stamp affixed to each document: I do not accept this offer to contract, and I do not consent to these proceedings. With Kelly's purported handwritten signature and a state of Illinois notary stamp and signature for June A. Barrett, dated October 29th of 2018. Then it says the origin of her STD claim, as well as 10 personal male witnesses testifying under oath about her sex life in support of her claim, and complete records of her text slash FaceTime message exchanges, which will be reviewed to match and be authenticated by the recipient to ensure there are no omissions or deletions. If Jane Doe really cares about her own reputation, she should cease her participation and association with the organizers of this negative campaign. Counteractions are in the developmental stages and due to be released soon. So that is what was said in that cease and desist kind of letter, right? Let me get something to drink. Yeah, I gotta go get something to drink. Give me a second, guys. I'll be right back. Oh. So the first attachment to the letter, attachment 1, was titled, Here's Jane Doe, your client. Attachment 1 contained 3 screenshots of Jane Doe from televised interviews. Below those photographs, the attachment read, Here's a sample of the real Jane Doe. Remember, she lives in Texas, so her claim of being intimidated falls flat because these pics were sent via text. Below that, attachment 1 included cropped nude photographs of Jane Doe, including a close-up photograph of Jane Doe's face and the top portion of her exposed breast, including a partial portion of her nipple area, and a photograph of Jane Doe kneeling on a bed, which included a partial portion of her exposed buttocks. Attachment 1 stated that the pictures had been cropped for the sake of not exposing her extremities to the world yet. The second attachment to the letter, attachment 2, consisted of 3 photographs of text messages, exchanges between Jane Doe and Kelly. In the exchanges, Kelly is called Daddy. Above the photographs of the Doe and Kelly, in the exchanges, Kelly is called Daddy. Above the photographs of the exchanges, attachment 2, read, Miss Jane Doe's usage of Daddy is / was her choice. It's very interesting how the difference in age only becomes a factor when things didn't go as she planned. So that's what he said underneath those photographs. I cannot. In December of 2018 and January of 2019, Russell, using his alias, Colin Dunn, sent a series of threatening and harassing text messages to Jane Doe and her mother, specifically on December 21st, 2018. Russell sent messages containing the same photographs of Jane Doe that were included in attachment 1 and stating, just a sample. We will seek criminal charges. You've been warned. Therefore, Russell sent additional messages stating, publishing soon, and this is colon. Don the con. My investigation will be done soon enough. Then on January 3rd of 2019, Russell sent additional text messages to Jane Doe and her mother, stating, "Pull the plug or you will be exposed." On January 6th of 2019, Russell followed through on his threats using the Kalan Dunn alias. Russell created a Facebook page named Surviving Lies, a play on the title of Lifetime's Surviving R. Kelly documentary, and posted screenshots of text messages between, let's pause there, and let's see what it says at the footnotes. So at the footnotes, it talks about at trial in Kelly, the government admitted into evidence text messages between Kelly and Russell's mother, June Barrett. See trial transcripts 2666 to 2693. Also, Government Exhibits 348A, Government Exhibit 348B. Those text messages showed that on October 26th of 2018, Kelly provided Barrett with the sexually explicit photographs of Jane Doe that were included in attachment 1. Barrett responded, "Do you have a way of sending me one more picture showing her phone number at the top? I'm going to print it and include it along with the other 3 and included them in the letter to her attorney." So at trial in Kelly, Jane Doe's mother testified about these text messages, which were admitted into evidence. Okay. So we're going over the facts of his case. Okay. So Kelly and Jane Doe, which contained the same sexually explicit photographs of Jane Doe. The Surviving Lies Facebook page was closed by Facebook on January 7th of 2019. Media reports indicated that Facebook deactivated the Surviving Lies Facebook page after posts targeting Jane Doe and another of Kelly's accusers were posted on the page. A January 7, 2019 article from the Daily Mail included screenshots from the Surviving Lies Facebook page that were posted on the page before it was taken down. Those screenshots included some of the same photographs of text message exchanges between Jane Doe and Kelly in attachment 2, including one where an address is disclosed. In addition, the Daily Mail article stated that cropped images of the same woman were also posted on the Facebook page, allegedly showing Kelly her breast augmentation following the surgery. So in late January of 2020, Russell appeared on 2 live interviews with vloggers. And these vloggers, as we know them to be, Texas Black Diamond and Nick at Night. Russell appeared on 2 live interviews with vloggers supporting Kelly and discussing Kelly's legal troubles, which were streamed live on the internet via YouTube. So during the first interview, Russell introduced himself as Kelly's advisor, consultant, and friend, and indicated that he had known Kelly for going on 30 years now. Thereafter, during the interview, Russell discussed Jane Doe and the lawsuit, holding up copies of items that had been sent to Jane Doe's civil attorney, described above. While holding up the first attachment to the camera, Russell stated, "That's my commentary at the bottom," referring to the text that appears below the 4 paragraphs. So during the second interview, Russell again held up copies of items that had been sent to Jane Doe's civil attorney, as described above. While holding up both attachments, Russell stated, "We sent these documents to the lawyer." Russell further stated, "These are the pictures of her, Jane Doe, that we sent. These are the text messages of her that we sent." So, dumb, and dumb, bozo, Don the Con, went on a YouTube tour and incriminated himself. And then expects to have his sentence vacated along with his conviction. Are you fucking kidding me? Yeah, no. Try to stick a pasta at the wall and see if it sticks. Throw a spaghetti at the wall and see if it sticks. That's why his motion to vacate is going to be denied. Denied. No, and no. Auntie Anne is going to look at this dude like he's fucking retarded and crazy. Like, wow. Wow, this guy's crazy. Hey, Martise. Hola, mami, ¿cómo está? Hey, T-Bam. Right, Mama Rogers. Give him the face. Yeah, no. This guy is fucking bozo. Another fucking bozo. I can't believe these bozos. Bunch of bozos running around YouTube and shit. Now, we're going to talk about the plea agreement and plea hearing. So the government says, on July 26th of 2022, the defendant pleaded guilty, pursuant to a plea agreement, to the sole count of the indictment, which charged him with interstate stalking from November 2018 to February of 2020, in violation of 18 U.S.C. 2261 A to B. See example A, executed plea agreement. Okay. The plea agreement included a stipulated United States sentencing guidelines range of 24 to 30 months imprisonment. That stipulated calculation included a 2-level enhancement because the defendant's offense conduct included a pattern or activity involving stalking, threatening, or harassing the same victim. So in the plea agreement, the defendant agreed not to file an appeal or otherwise challenge by petition pursuant to 28 U.S.C. Section 2255 or any other provision, the conviction or sentence in the event that the court imposes a term of imprisonment of 33 months or below. The defendant also waived all defenses based on the statute of limitations and venue, as well as the right to raise on appeal or on collateral review any argument that 1. The statutes to which the defendant is pleading guilty is unconstitutional, and 2. The omitted conduct does not fall within the scope of the statutes. Man, listen, this guy denied. What the hell is wrong with him? Is he dumb, stupid, or slow? I want to know. Because I'm confused. Why did he even waste paper, ink, and time to do a 2255? Knowing he made this agreement, signed off on it. So you mean to tell me he signed off on it and didn't read it? What? I'm sorry. A bitch like me is going through a hearing process and all this bullshit. I'm reading every goddamn piece of paper that floats through my face. And I'm not missing a beat. Because this is my life on the line. So I gotta know what I'm signing up for. Is Don a fucking tarant? Yes, he is. You fucking tarant. You and R. Kelly, y'all both stupid, dumb, and slow. I mean, really? With friends like you, who needs enemies, Don? Ay, ay, ay. And at the outset of the plea hearing, but after he was sworn, the defendant confirmed that he wished to plead guilty to the sole count of the indictment pursuant to a plea agreement with the government. See example B, the guilty plea transcript at 220 and 302. The court advised the defendant that he was making a serious decision and that the court must be sure that you understand all the consequences of pleading guilty, as well as the rights you're giving up. And the court continued. Okay. And the court continued. I'm going to explain those rights to you. And then I have to ask you a number of questions to make sure that the plea is valid. If there's something that you don't understand, you want me to repeat, just let me know. And if at any time during the course of today's proceeding, you need to talk to your lawyer about anything, let me know that too. I'll give you as much time as you need. And then at the 303 mark in the transcript, the defendant thanked the court, confirmed that he understood the potential repercussions of lying under oath, and stated that his mind was absolutely clear And the defendant further confirmed that he had discussed the charge with his lawyer, that he understood the charge, and that he was absolutely satisfied with his lawyer's representation in this case. The court reviewed with the defendant the rights he would be giving up by pleading guilty. The defendant was informed of his right to persist in his plea of not guilty and to a speedy and public trial. The right to assistance of counsel, the right to confront and cross-examine witnesses, and the right not to testify, amongst other things. The defendant confirmed that he understood each of those rights and that he additionally understood that by pleading guilty, he was giving up those rights. The court asked the defendant whether he needed any additional time to talk to your lawyer about any of the topics the court had discussed with him at that point. The defendant stated he did not have any questions and that he was pretty clear on everything. I don't know if he heard too clear. He must got a lot of wax in his ear. As to the terms of the plea agreement, the defendant confirmed that he had sufficient time to discuss those terms with his attorney, that he did not have any questions about the terms of the plea agreement, and that no one had made any promises to him that were not contained in the agreement or threatened or forced him to accept the agreement. The court then asked the government to place the statutory penalties, which were contained in the plea agreement, on the record, and the government did so. The defendant confirmed that he understood the potential penalties. The court then turned to the United States sentencing guidelines. The defendant confirmed that he had discussed how the guidelines might be applied in this case with his lawyer. The government placed the guidelines estimate, which was also contained in the plea agreement, on the record, and the court explained to the defendant that the estimate could be wrong and that there was no guarantee that you're going to get a particular guideline range or sentence. The court also informed the defendant that if the sentence that you get is different than what you expect, you're not going to be able to take your plea back. The defendant confirmed he understood. So if you understood, why the hell would you waste your time making a 22-5? Huh? I'm confused. Desperate times call for desperate measures. I see. Wink, wink. Like, what the fuck? I mean, his mind is foggy, cloudy, good chance of storms coming through. And his understanding was zero. I mean, he is a pothead. But let me tell you something. Okay? He must have been really fucking stoned to agree with everything and not understand anything. I mean, because if I'm too stoned, I'm not reading shit. I'm not understanding. I'm not comprehending. I'm high. I want to be left alone in peace, floating on my cloud. Like, I hope he wasn't. Because to my understanding, he had to be clean. He had to be clean while he was out on bail. So he couldn't smoke no weed. So, yeah, he was getting drug tested once a week when he started out. I don't know if they lessened it as, up until his trial date or whatever, you know what I mean? Yeah. The court again informed the defendant that as part of your plea agreement, you've agreed not to file an appeal or challenge the conviction or a sentence as long as I impose a sentence of 33 months or shorter. See, the government was being nice with your ass. You see? They were like, all right, listen. Okay? As part of your agreement, okay, you have to agree that you can't come over here with no damn appeals and no challenges about your conviction or your sentence. Okay? As long as I, the judge, okay, we made an agreement. As long as I, the judge, gives your ass 33 months or shorter, I did that. I gave you 20 months. And now you're coming to me. I'm going to act like I'm Auntie Anne. And now you're coming to me to slap me in the face with some bullshit. Right? Get the fuck out my court. Get your ass back to jail. Shut the fuck up. Wow. This dude, he's a wise guy. And then again, the defendant again confirmed he understood. He further confirmed that he understood all of the other topics the court had, I guess, presented, right? Let's go to the next page. That the courts had discussed with him. That he did not have any questions and that he did not need any additional time to consult with his lawyer before pleading guilty. Before proceedings to take the defendant's guilty plea, the court again confirmed with the defendant that he was pleading guilty voluntarily and of his own free will. That no one had threatened or forced him to plead guilty. And that, other than the agreement, no one had promised him anything to get him to plead guilty. And I said that before when I was reading his shit. You can't do that. The judge is going to ask you the day of that hearing, do you understand everything? Do you comprehend me? Are you sure you want to do this? Did anybody try to force you or threaten you or anything like that? And he says, no, everything's good. Then that's what the fuck it is. And it stands on that. And that other than the agreement, no one had promised him anything to get him to plead guilty. And now he's crying that his lawyer coerced him. I cannot. I mean, He's funny. He's a funny guy. He's a funny guy. Funny dude. You a funny dude. Mitzi said Colin Don pulled something similar to this just before or after he was sentenced. Sounds like he's trying to work up on insanity. He damn shows sounds. Right, Matisse. Like, what the fuck is wrong with you? You know they went over this with you at your hearing. You made a whole agreement and said, listen, I'm not coming back to sue nobody. I'm not coming back to release myself. I'm just going to take my time and go. Do it, get it over with, and I'm done. I plead guilty. That means I'm going to take my L, I'm going to slap it on my forehead, and I'm going to walk around like a fucking loser with big balls. Because that's what you look like right now. A big loser with big balls. A real fucking tarant. Yeah. Before proceeding to take the defendant's guilty plea, the court again confirmed with the defendant that he was pleading guilty voluntarily of his own free will, y'all. And that no one threatened him or first forced him to plead guilty, y'all. But yet he's saying, screaming, ineffective counsel. That's crazy. I can't get over him. He's too much. He's too much. So the court reminded the defendant of the charge to which he was pleading guilty and asked the defendant what he did to make him guilty of that charge. They even asked him, what made you guilty of the charge? And he answered, I bet. Of course, right? After some engagement with the defendant about the conduct underlying the charges, the court allowed the government to pose specific factual questions to the defendant relating to the elements of the charged offense. So, in response to those questions, the defendant admitted that he sent the messages to Jane Doe and her mother described above. Specifically, the defendant admitted that he sent messages to Jane Doe and her mother on December 21st, 2018, containing cropped nude photographs of Jane Doe that showed her exposed breast and buttocks and stating, just a sample. We will seek criminal charges. You've been warned. He further admitted that those messages stated that the pictures had been cropped for the sake of not exposing her extremities to the world yet. The defendant further admitted to sending the messages stating, publishing soon. And this is Kalan. My investigation will be done soon enough. The defendant also admitted that he sent a message to Jane Doe and her mother on January 3rd, 2019, stating, pull the plug or you will be exposed. The defendant further admitted to creating the Surviving Lies Facebook page and publishing similar photographs of Jane Doe on that page. The defendant admitted to appearing on YouTube in January 2020 and holding the photographs of Jane Doe up for the camera. Finally, the defendant confirmed that he engaged in all of this conduct with the intent to harass and intimidate Jane Doe and the immediate family member of Jane Doe. The court found that the defendant was fully competent and capable of entering an informed plea, that he was aware of the nature of the charges and the consequences of pleading guilty, that his plea was knowing and voluntary, and that there was an independent factual basis to support the plea that included the essential elements of the defense. The court accordingly accepted the defendant's guilty plea. Okay. Post plea conduct. After the government filed its sentencing submission, the government discovered that on July 27, 2022, the day after the defendant pleaded guilty in this case, the defendant gave a YouTube interview titled Donnell Russell Talks About the New York Trials and Why He Took a Plea Deal. That was Texas Black Diamond's video. He did that shit with TBD. Ah, that is funny. During the interview, the defendant discussed this case, as well as his criminal case in the Southern District of New York. As to this case, the defendant repeatedly minimized his offense, conduct, and demonstrated an utter lack of remorse for harassing and threatening Jane Doe, and for publicly posting sexually explicit photographs of Jane Doe to Facebook. For example, the defendant referred to Jane Doe and her mother as questionable and boasted about threatening Jane Doe and her mother. Wow. You're a bozo. You're another fucking bozo. Seriously. Mm-mm-mm. Give me a second, guys. I gotta stretch my leg. I had to stretch my legs a little bit. This neuropathy sometimes be bothering me, and my legs fall asleep and stuff. Okay, so let's go to the next page. Here we go. So now they're going to talk about the sentencing. On November 17th of 2022, the court sentenced the defendant to 20 months imprisonment, which was 4 months below the bottom of the applicable guidelines range of 24 to 30 months imprisonment. See exhibit, I guess, C, sentencing transcript. The defendant did not contest the guidelines calculation contained in the pre-sentence investigation report or raise any factual disputes relating to the offense conduct described in the PSR. In explaining the reasons for its sentence, the court stated, among other things, that this was a campaign of threats and intimidation that lasted for over a year, which involved threatening somebody with humiliating pictures or information about them, threatening to put it out over the internet where it could last forever. Oh, give me a second. The court further stated that the defendant engaged in this campaign of threats and intimidation because Jane Doe had the nerve to challenge R. Kelly by filing a lawsuit. All right. Give me 1 second, guys. I got to take a quick break. I got to use the restroom.
You are watching Diva Divine Light.
You can fuck with me if these red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut every nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the game so much, I know they tired of me. Honest.
You are watching Diva Divine Light.
You can fuck with me if these red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut every nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the game so much, I know they tired of me. Honest.
You are watching Diva Divine Light.
You can fuck with me if these red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut every nigga.
Okay, I'm back. Sorry about that, guys. Had to take a quickie. All right, let's continue. So, the court should deny the defendant's motion to vacate his conviction and sentence. And now we're going to talk about the applicable law. To obtain relief pursuant to the section 2255, okay, a defendant must establish a constitutional error, okay, a lack of jurisdiction in the sentencing court, or an error of law or fact that constitutes a fundamental defect which inherently results in a complete miscarriage of justice. So, when you go to file this motion, you have to establish those elements, okay? That there has to be some type of constitutional error within the law, right? there has to be some lack of jurisdiction in the sentencing court, which is where the courts were holding the proceedings, right? Or an error of law or fact that constitutes a fundamental defect, which inherently results in a complete miscarriage of justice. So there had to be some type of error that was put in that goes according to whatever laws. Something was a mistake. That case law didn't go with the case. So, stuff like that. Or a fact that constitutes a fundamental defect. Okay? So, some type of fact of the law that could constitute some type of defect, which made a miscarriage of justice. That's the only way. And as relevant here to prevail on an ineffective assistance of counsel claim, a defendant must show, one, that his attorney's performance fell below an objective standard of reasonableness, and two, that as a result, he suffered prejudice. Okay? Okay. Now, as to the first Strickland prong, because they were talking about two Strickland prongs. As to the first one, in assessing the reasonableness of counsel's performance, judicial scrutiny must be highly differential and must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. The reasonableness of counsel's performance is to be evaluated from counsel's perspective at the time of the alleged error and in light of all the circumstances, bearing in mind that there are countless ways to provide effective assistance in any given case, and that even the best criminal defense attorneys would not defend a particular client in the same way. Because there are countless ways to provide effective assistance in any given case. Even the lack of success of a chosen strategy should not cause a court to second guess an attorney's judgments. In the context of ineffective assistance of counsel, claims based on alleged failure to advise a defendant who pleaded guilty of a possible defense, courts look to the viability of the defense in determining whether counsel's performance was constitutionally unreasonable. And in the other case of the United States versus Keith, states that any motion to suppress would have been without merit strongly weighs against a finding that counsel's performance was constitutionally unreasonable. Constitutionally unreasonable in failing to investigate such a motion or advise his client he could eschew the plea and file one. Okay, so in Jameson versus Sanowski, in the Southern District of New York in 2002, petitioner's arguments are unavailing because he cannot show that even if his attorney did fail to alert him to such defenses, such a failure falls below objective standards of reasonableness. In short, Jameson has not shown that these defenses were in fact viable. In Panuccio versus Kelly in 1991, holding attorney's failure to advise his client of an affirmative defense did not render the assistance ineffective, where counsel had every reason to think that raising the defense had almost no chance of success. Okay. So the principal value of, okay, wait, I'm sorry. I'm trying to get it right. The principal value of counsel to the accused in a criminal prosecution often does not lie in counsel's ability to recite a list of possible defenses in the abstract, nor in his ability, if time permitted, to amass a large quantum of factual data and inform the defendant of it. Counsel's concern is the faithful representation of the interest of his client, and such representation frequently involves highly practical considerations as well as specialized knowledge of the law. Okay. Okay. And then they're showing another example. I was just trying to, hold on. Here we go. As the second Strickland prong, in order to show prejudice, a petitioner must show a reasonable probability that, but for counsel's defective performance, the results of the proceedings would have been different. Indeed, the ultimate focus of inquiry is whether the results of the particular proceeding is unreliable because of a breakdown in the adversarial process. In the context of a conviction based on a guilty plea, that means the defendant must show that there is a reasonable probability that, but for counsel's errors, he would not have pleaded guilty and would have insisted on going to trial. So in this regard, the fundamental question is whether the plea represents a voluntary and intelligent choice among the alternative courses of action open to the defendant. Generally, a defendant who has no realistic defense to a charge supported by sufficient evidence will be unable to carry his burden of showing prejudice from accepting a plea bargain, a guilty plea. Explaining further that a defendant facing such long odds will rarely be able to show prejudice from accepting a guilty plea that offers him a better resolution than would be likely after trial. So the Second Circuit has noted that the prejudice prong is not satisfied merely by a defendant's testimony that he would have gone to trial had he known of the defense. Since the defendant's testimony after the fact suffers from obvious credibility problems, liar, liar, pants on fire, the weight of authority among our sister circuits holds that a self-serving and conclusory statement of this kind is insufficient in itself to show prejudice in the context of guilty pleas. Moreover, the petitioner must also contend with the fact that his own sworn statements at a plea proceeding admitting all the elements of the charge to which he is pleading guilty carry a strong presumption of verity. So, do we believe you now or do we believe you then, Don? Hey, Open, what's up, baby? What's up, what's up, Ears? What's up, Open? What's up, y'all? Good to see my brothers in the neighborhood. What's up, y'all? So I'm just reading Don Russell's bullshit because he's an idiot. So now when a defendant has explicitly stated in his allocution that he fully understands the consequences of his plea and that he has chosen to plead guilty after a thorough consultation with his attorney, a district court on habeas review may rely on the defendant's sworn statements and hold him to them. So the representations of the defendant at a plea colloquy constitute a formidable barrier in any subsequent collateral proceedings. Okay. A defendant's sworn statements during plea proceedings carry such a strong presumption of accuracy that a district court does not, absent a substantial reason to find otherwise, abuse its discretion in discrediting later self-serving and contradictory testimony as to whether a plea was knowingly and intelligently made. Well, I don't know, but this guy over here, Don Kalan Dunn, doesn't seem too intelligent at all. So finally, in deciding an ineffective assistance of counsel claim, a court need not address both prongs of the Strickland inquiry if the petitioner makes an insufficient showing on either one. So in particular, a court need not determine whether counsel performance was deficient before examining the prejudice suffered by the defendant as a result of the alleged defense deficiencies. Sorry. So the defendant has not shown that his lawyer was constitutionally ineffective. As noted above, the defendant argues that his counsel's performance was constitutionally deficient because his counsel allegedly failed to advise him about 4 substantial defenses. Specifically, the defendant argues he should have been advised about the following 4 defenses. Right? We talked about his innocence, the 6th Amendment, venue challenge, legal defense of the interstate stalking statute, and First Amendment challenges. So the defendant asserts that had his counsel advised him of these defenses, he would have asserted them rather than pleading guilty. As discussed below, even assuming arguendo that counsel did not discuss the above listed challenges with the defendant, that would not have rendered his assistance ineffective because none of the defenses were likely to succeed in this case. So, no matter what, even if you would have went to trial, Don, you still would have been found guilty. So if you would have pleaded guilty or you would have been found guilty, doesn't matter. Then it says actual innocence. The defendant argues that his lawyer was ineffective, failing to advise him about a defense of actual innocence. Specifically, the defendant argues that his offense conduct, the facts of which he does not dispute, is not prohibited by the 18 U.S.C. 2261A 2B, and that his counsel failed to advise him of that. This argument is without merit. As relevant here, a defendant is guilty of violating 18 U.S.C. 2261A 2B if he, 1, with the intent to harass or intimidate, 2, uses the mails or any interactive computer service or electronic communication service or electronic communication system of interstate commerce, or any other facility of interstate or foreign commerce to engage in a course of conduct. 3, that causes, attempts to cause, or would be reasonably expected to cause substantial emotional distress to the victim or her immediate family. 18 U.S.C. 2261A 2B, model jury instructions. A course of conduct is defined as a pattern of conduct composed of 2 or more acts, evidencing a continuity of purpose. 18 U.S.C. sections 2266. So here as set forth above and in the PSR, and as the court detailed at sentencing, the defendant repeatedly harassed and intimidated Jane Doe and her mother from November 2018 to February 2020 in an attempt to get Jane Doe to drop her lawsuit against Kelly. First, in November 2018, the defendant caused a letter purportedly signed by Kelly to be mailed to Jane Doe's attorney in Brooklyn, New York. That letter enclosed sexually explicit photographs of Jane Doe and threatened to expose Jane Doe's extremities to the world if she did not dismiss her lawsuit against Kelly. All right, so we already know all of this. I'm not going to reread this. Okay. At the guilty plea proceedings, the defendant admitted under oath to sending the described text messages, creating the Surviving Lies Facebook page, and publishing photographs of Jane Doe on that page. Also, appearing on YouTube in January of 2020 and holding the photographs of Jane Doe up for the camera. He further admitted that he engaged in all of this conduct with the intent to harass and intimidate Jane Doe and the immediate family members of Jane Doe. At sentencing, the defendant did not contest any of the offense conduct described in the PSR or request a hearing. As the court has already found, the above described conduct includes the essential elements of the offense. Now, in the plea transcripts at 2422 and 2505, specifically, the offense conduct includes the defendant using the emails, cell phones, and the internet. Example, Facebook and YouTube, to engage in a course of conduct, repeatedly harassing and intimidated Jane Doe and her mother, with the intent to harass and intimidate Jane Doe and her mother, for the purpose of forcing Jane Doe to drop the lawsuit. Accordingly, the defendant's lawyer was not ineffective for allegedly failing to advise the defendant on a potential defense of actual innocence. In any event, as explained below, the defendant cannot show prejudice resulting from any alleged failure by his lawyer to advise him of an actual innocence defense. Venue challenge. The defendant's argument that his lawyer was ineffective for failing to advise him that he could raise a venue challenge is also without merit. Now, under Federal Rule of Criminal Procedure, Criminal Procedure 18, venue is proper in a district where the offense was committed, as the Second Circuit has explained, where the acts constituting the crime and the nature of the crime charged implicate more than one location. The Constitution does not command a single exclusive venue. As particularly relevant here, the Second Circuit's cases on phone calls, emails, text messages, faxes, chat room messages, and wire transfers as overt acts illustrate that the government can establish venue where such electronic communications were sent to or received by individuals in the venue district. Okay. So here, as detailed above and in the PSR, to which the defendant raised no objection, the defendant caused a letter purportedly signed by Kelly with attachments including sexually explicit photographs of Jane Doe and threats to expose those photographs to the world, to Jane Doe's attorney in Brooklyn, New York, because Brooklyn is located within the Eastern District of New York. Venue is proper here. So accordingly, the defendant's lawyer was not ineffective for allegedly failing to advise him of a potential venue challenge. In any event, as explained below, the defendant cannot show prejudice resulting from any alleged failure by his lawyer to advise him of a potential venue challenge. So the First Amendment challenges. The defendant argues that his lawyer was constitutionally ineffective because, according to the defendant, his lawyer failed to advise him of potential First Amendment challenges to Section 2261A. Specifically, the defendant appears to argue that his lawyer was ineffective for failing to advise him of possible facial, overbreadth, and as applied First Amendment challenges to the statute. These arguments also fail. All right. All right. I'm going to skip over all that. Now, the defendant's argument that his lawyer was ineffective for failing to advise him of a potential as applied challenge to Section 2261A is equally unavailing. An as applied challenge requires an analysis of the facts of a particular case to determine whether the application of a statute, even one constitutional on its face, deprived the individual to whom it was applied of a protected right. Under well-established Supreme Court precedent, speech integral to criminal conduct, is not protected by the First Amendment. Okay. Under these precedent, federal courts addressing as applied challenges to Section 2261A under analogous circumstances have routinely rejected those challenges. For example, 2261A, for example, in Ossinger, the Ninth Circuit rejected an as applied First Amendment challenge to Section 2261A, where the defendant sent threatening text messages implying that he had sexually explicit photographs of a victim, created a Facebook page where he posted sexually explicit photographs of the victim, and sent emails to the victim's coworkers containing sexually explicit photographs. The court reasoned that any expressive aspects of the defendant's speech were not protected under the First Amendment because they were integral to criminal conduct in intentionally harassing, intimidating, or causing substantial emotional distress to the victim. Okay, I pretty much read that. Okay. Here, as in this case above, as in the cases above, the defendant's mailings, text messages, and internet postings were integral to his criminal conduct. They served only to harass and intimidate Jane Doe and his mother in an attempt to force Jane Doe to drop her lawsuit against Kelly. So, any as applied First Amendment challenge would not have been viable in this case. Accordingly, even crediting the defendant's post hoc assertion that his counsel did not advise him of any of an as applied First Amendment challenge, counsel's performance would not have been constitutionally ineffective. In any event, as discussed below, the defendant cannot establish prejudice. Okay. Okay, sorry guys. Hold on. I lost my spot. All right. So then he talks about the venue challenges. Okay. Okay. Finally, the defendant argues that his counsel was ineffective for failing to advise him of potential as applied vagueness challenge to Section 2261A. This argument also fails. The void for vagueness doctrine requires that a penal statute define the criminal offense, one, with sufficient definiteness that ordinary people can understand what conduct is prohibited, and two, in a manner that does not encourage arbitrary and discriminatory enforcement. Okay. Okay. Here, as discussed extensively above, the defendant's conduct falls within the core conduct prohibited by Section 2261A, and the defendant himself confirmed under oath that he participated in that conduct with the intent to harass and intimidate Jane Doe and the immediate family members of Jane Doe. All right. Let me basically. All right, let's see. Okay. As detailed above, none of the defenses identified by the defendant would have been likely to succeed in this case. To the contrary, the constitutional defenses he identifies have routinely failed in similar cases, and the venue challenge he identifies, even if successful, would have resulted only in the prosecution's transfer to a different district. They're like, listen, it doesn't even matter because you know what? If there was something wrong, we would bring you to the right place. We would transfer it to the different district. So at the same time, the government's evidence against the defendant was overwhelming. At a trial, the government would have induced the following, among other evidence. 1. The threatening letter sent to Jane Doe's attorney, which included sexually explicit images of Jane Doe and the above described YouTube videos, during which the defendant takes credit for sending them. 2. The above described threatening text messages from the defendant using Colin Dunn's alias to Jane Doe and her mother in December of 2018 and January 2019. And 3, evidence demonstrating that the defendant created the Surviving Lies Facebook page and posted sexually explicit photographs of Jane Doe to that page. Had the defendant proceeded to and been convicted at trial, his guidelines range would have been 33 to 41 months imprisonment. Because he pleaded guilty and received a 3-level reduction to his offense level, his guidelines range was 24 to 30 months imprisonment, and he received a below guideline sentence. Given the evidence against him, the unavailability of any viable defense and the benefit he received by pleading guilty, the defendant cannot establish that he was prejudiced even if his counsel's performance was deficient. There always remains the possibility that Marshall might have gone to trial anyway, confident that he could persuade the jury to believe his version of events. But we do not believe that there is a reasonable probability that Marshall would have seized the modest change at acquittal, given the risk inherent to doing so. The potential defense Forrest now raises would have failed, and thus he does not satisfy the prejudice requirement of the Strickland standard. Okay. All right. This is the last page, and then I'm out of here, guys. Okay. All right. For the reasons above, the court should deny the defendant's motion to vacate his conviction and sentence. For the same reason, the court should deny the defendant's motion for bail pending resolution of the motion. Okay. So that is that. That is that for now. I have other parts to this, but I'm ready to go to bed, y'all. I am. I'm tired. So the government says, no, you can't do this. No, you can't do that. No, womp womp. You're wrong. Denied. You got to show your proof. And you ain't got shit. All right, so guys, everybody that's there, please make sure you hit that like button on your way out, guys. Thank you so much. Please like. Thank you. Give me the thumbs. It's free. Even the ones in the bushes. Gracias. And make sure you share the show. Subscribe to the channel. Hit the notification bell on all. And your girl, Diva Divine Light, is out. Peace.
You are watching Diva Divine Light.
You can fuck with me if These red bottoms, these bloody shoes. Hit the scoop, I can get them both. I don't wanna choose, and I'm quick. Cut every nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what or who? Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I can play. I be in and out the bank so much, I know they tired of me. Honest, honest.